Hello, everybody. It's Roger Royce with Ains Boone and host of the 10,000 Startups podcast. The case of Astralabs or Newchip Accelerator has been in the news lately. Just last week, I see TechCrunch did another article on their bankruptcy. You may recall that this is an accelerator in Austin, Texas that filed bankruptcy about a year ago. And it's an interesting case. It was an accelerator and they filed under Chapter 11. It was somehow converted to a 7 later. What that means, a Chapter 11 is a reorganization, whereas a Chapter 7 is basically a liquidation. And as part of that process, the court ordered, as it always does, that the bankrupt debtor, being Astralabs, sell all its assets, use whatever money it has to pay its creditors to the extent it can in the order of priority required by the statute. Well, what's interesting about this case and why it's in the news is that their big asset consists of warrants in their tech startup companies that were in the accelerator. Now, like most accelerators, they had two components to, at least two components to their compensation. One was a fee that they would charge companies for joining their program. And the second is an equity component. And that's very common. That's how it's always done. In fact, usually we'll split that up and we'll put the equity in a fund that sits alongside the service providing accelerator, put the fee in the accelerator. The fee should cover costs and who knows, maybe leave a little bit left over for compensation salaries. But the big gains are going to be in the equity component because this is startup land where 1 in 100 companies is going to be a home run. And I haven't seen their warrants. I only know what I read in the press. But what's interesting to me about this case is the court's focus on these warrants, because it's about the only time we ever see warrants anymore is in connection with accelerators. And there was a time when we did financing, venture capitalists would get warrants on top of whatever their security was. Anyone who was doing a debt financing often had warrants attached to the debt. And that's all changed now. So now when you see warrants, it's because there's an accelerator that wants to maintain an equity position. And warrants can come in almost any flavor that people want. And these particular warrants, according to the article, have an exercise price equal to the current value as of the date of the grant of the warrant. Now, a warrant is simply a right to buy stock. So we get an early stage startup company into a program, give me a warrant to buy 5% of your stock at $1 a share. And by the time that I come around to wanting to exercise that warrant, or when the company exits and I get paid out, the stock's worth $10 a share. So just like an option, I've made $9. It's really interesting that accelerators do these for so many reasons. But the biggest reason I think they do it is typically in an accelerator context, I see the warrant structured as a percentage of the company. So that can really requires a little bit of thought on behalf of the entrepreneur, because you need to know, because that means you're taking dilution up to a certain point. And you really need to get the spreadsheets out and do some what ifs and figure out, just because that 5%, after a couple of rounds of funding is way more than 5% today. So it's really worth doing the what ifs. And we all have to get good at Excel and sort of figure that out. Secondly, warrants will have a term. So good to note, how long is that warrant going to stay out there? And typically, a warrant will just expire unless you have an exit before the expiration of the warrant, because who wants to come out of pocket to invest in illiquid startup company stock that might never go public? And then the really interesting thing, though, is that almost all warrants have what we call a net exercise feature. So remember, a warrant is just a right to buy stock. So in my example, with nothing else, that means to exercise this $1 warrant, somebody has to pay $1 a share and then hold the stock and then sell it in the exit. But net exercise means that you don't pay $1 a share. The company just gives you $9 per share worth of stock. You net exercise. You pay the exercise price with the warrant stock itself. We see that in options. It's not uncommon, but that's one that the company who's granting the warrant probably needs to know about, because if you're counting on a lot of money coming in when people exercise the warrant, you're going to be disappointed because that hardly ever happens. And then finally, like I say, just knowing how much dilution you're going to take. Now, in the Astralabs case, and I know nothing about it other than what I read in the press, but I can guess that these warrants are likely transferable because they always are. Um, Now, sometimes a venture capital warrant will put some restrictions around those transfers. You got to buy so many shares of stock, etc., just to avoid driving a company crazy with having a million warrant holders. But for the most part, the warrant holder will negotiate for transfer. And I'm guessing that's what happened, is that now the company is out there because it's an asset of the estate. But, even if it weren't, just keep in mind, bankruptcy has its own special rules around transfer restrictions and other types of restrictions on contracts. So who knows where that would come up. But in any event, Astralabs, interesting case. I'm going to keep an eye on it. I don't care about all the drama behind the scenes, the personalities involved, the bankruptcy aspects, but I do think it is quite fascinating that these warrants are front and center. And what this case is illustrating is just how super valuable accelerator warrants in startup companies could be. Roger Roy's 10,000 Startups podcast.